Start. Opposition to the death penalty is often rooted in arguments about its irreversibility, its essential cruelty, the possibility of error, and the false sense of justice in doing unto convicted murderers what they had done to their victims. In the Indian context, politics surrounding the prisoner's ethnic origin or linguistic affinity is often the basis for pleas for clemency. Rarely is a more compelling reason invoked the possibility of an offender's economic background, educational level, social status, or religious identity working against his interests in legal proceedings. A report released on Friday by the National Law University, Delhi, on the working of the death penalty in India provides validation and proof for something that those familiar with administration of justice knew all along, that most of those sentenced to death in the country are poor and uneducated, and many belong to religious minorities. In addition, a revealing number is that as many as 241 out of 385 death row convicts were first-time offenders. Some may have been juveniles when they committed capital offenses but lacked the documentation to prove their age. Against the salutary principle that those too young and too old be spared the death sentence, 54 death now convicts whose age was available were between 18 and 21 at the time of the offense, and 7 had crossed 60 years of age. An average prisoner awaiting execution is likely to be from a religious minority, a Dalit caste, a backward class, or from an economically vulnerable family, and is unlikely to have finished secondary schooling. The late President APJ Abdul Kalam had once said a study by his office into the background of convicts seeking mercy showed a social and economic bias. He digressed from his prepared text during a public lecture to ask, why are so many poor people on death row? The link between socio-economic standing and access to competent legal counsel and effective representation, standing and access to competent legal counsel and effective representation is quite strong. A question of concern that arises is whether these statistics indicate systemic bias or institutionalized prejudice. It is not uncommon that legal grounds unavailable to the vulnerable are invoked in favor of the influential. A recent instance is that of 4 prisoners from a political party who were sentenced to death for burning a bus during a protest and killing 3 women students. The court, while commuting their sentence, invoked the doctrine of diminished responsibility and reasoned that those gripped by mob frenzy were not fully cognizant of the situation around them. While invoking any ground to commute a death sentence to life is welcome, the impression is inescapable that such relief often comes at a very late stage and only to those with the means to pursue legal remedies till the very end. When a judicial system that is seen as favoring the influential resorts to capital punishment, it will be vulnerable to the charge of socio-economic bias. Law and society, therefore, will be better served if the death penalty itself is abolished. These statistics must reinforce the larger moral argument against the state taking the life of a human being as punishment. Expectedly, tobacco companies are registering a new regulation that the mandatory pictorial warnings on cigarette packages be made larger. The legal challenge to the new rule is likely to be finally settled in the weeks ahead, but till then, as per the Supreme Court's directives, the larger warnings must be printed. For now, cartons will have up to 85% of the packet devoted to graphic messaging. Having lost the argument on the health effects of cigarette consumption as well as passive smoking, cigarette makers are pleading that tobacco growers will be adversely affected. Experience in other countries suggests that they are fighting a losing battle. Australia has become something of a shining example for the rest of the world to follow in clamping down on suggestive branding. In 2012, it pioneered a move to have cigarettes sold in logo-free plain cartons to deter smokers. This month, the European Court of Justice backed a measure to cover 2/3 of a cigarette packet with health cautions in the 28 member states of the European Union. Earlier, the ECJ had prohibited the use of descriptive terms such as light and mild to differentiate among cigarettes. This was in addition to the mandatory disclosure on cigarette packs of the ingredients. The smoking habit is often picked up by suggestive nudges through advertising, peer pressure, and cultural signals that associate smoking with hipness, attitude, stress busting, and so on. Indeed, Canberra's post-implementation report shows that there has been a statistically significant drop in the prevalence of smoking since packages have gone logoless.